Madam Chief Justice, Madam Deputy Chief Justice, my lords, my ladies, I am to address myself to the sixth issue of the court, whether the IBC carried on the verification, tallying and declaration of results in accordance with Article 138(3)(c) and Article 138(10) of the Constitution. The thrust of my presentation is that the nature of management of elections in Kenya from even before the new constitution have been that decisions as to who has won the presidential election are collegiate. And that the collegiate nature of the decision as to who is the winner of a presidential election goes down to the description of what is a free and fair election under Article 81. And in Article 81E, the Constitution describes a free and fair election as an election, E3, conducted by an independent body, 4, transparent, and 5, administered in an impartial, neutral, efficient, accurate, and accountable manner. And it is my submission that this goes not to just what the Constitution says, but what Kenyans have practiced and what they have come to expect whenever bodies are making decisions. Possibly more than any other body, the judiciary has been able to show Kenya the nature of collegiate decision making. We have had live court sessions from the High Court to the Court of Appeal to the Supreme Court. Kenyans have seen often the presiding judge, in this case even the Chief Justice, consult even sometimes openly with other judges before the court arrives at a decision on even very small things. And we have even had situations when a decision becomes grave. We have seen judges retire to go so that they come back with a collegiate decision. So that is what Kenyans have come to expect, and that is also what Kenyans expect even from the Independent Electoral and Boundaries Commission. First, the nature, our commissions are made up of at least 3 members and at most 9. And if you look at the qualifications of all these members, they are all, whether it is the chairman or the members, largely have the same qualifications. They are all identified and recommended for appointment among the same criteria. They are all approved by the National Assembly. They are all appointed by the President. So there is no basis on which the chair of any commission can treat as subordinate members of that commission or treat them as if they have lesser qualifications or lesser competencies than him. They all enjoy the same security of tenure. They all enjoy the same security in their remuneration. And so they are all expected to execute very substantive mandates. My Lord, this question as to the mandates of commissioners came up in the case of Michael Kamau versus the Ethics and Anti-Corruption Commission, which is in our list of authorities, came up in the High Court and came up in the Court of Appeal. And the court, both courts were very categorical as to the fact that the constitutional mandate of a commission is borne by the commissioners. And in that case where a commission had attempted to reach a decision without commissioners, the court annulled that decision and said that that decision had to be made by commissioners. And in respect of the powers of a chairperson, again, the minor KI case, all the way from the High Court to the Court of Appeal and to this court, have made it clear that the chairperson is not the commission and that he has to act with the rest of the commission for him to deliver a proper constitutional decision. So that collegiate nature of the decision making in a commission is captured very well in Article 138 3C and in Section 39 1C of the Elections Act, which make it very clear that it is for the commission to tally and verify the results. And in Article 138.10 is only where the chairman is asked to declare the result of that decision. And our submission is that the requirement to declare does not give the chairman any power to tally, to verify, or even to reach a decision as to what he is going to declare. That part of the Constitution was first captured in Section 41 of our previous Constitution, in subsection 11, which had a proviso that provided any decision of the commission shall require the concurrence of a majority of its members. And that is why I say the collegiate nature of decision making at the Electoral Commission even precedes our new constitution. And at that time, there was an attempt, which I will submit is an attempt that has also been made this time by the chair of the Electoral Commission,